Welcome. My name is Carl Linder, and I co-chair the International Wealth and Asset Planning Group at Greenspoon Martyr, along with Ed Brown. My office is in Miami, Florida, and Ed is in the Denver office. Our bios are on the screen. Today, we're going to be discussing issues related to some of the estate tax planning changes that will occur under a Biden administration. We have been given a good amount of insight into what the future holds for the estate tax. Obviously, a lot is depending on who's going to control Congress come January 5th. There are two very contested elections in Georgia, which will determine the future for the estate tax in the United States. Currently, we have a very high estate tax exemption. A married couple can actually pass 23,580,000 economic value of assets. That is without discounting, and there's some additional savings that can be had with discounting, and we'll get into that a little later. But we are going to discuss some opportunities in relation to the tax changes that we expect. I'd like to let Ed give a couple intro comments and speak a little bit about estate tax.
Sure. Thanks, Carl. Yes, this is obviously a very popular topic this time of year, and it's probably going to get more popular over the next 3 weeks. Hopefully the questions will cease on December 31, because it's probably too late to do anything at that point. Matter of fact, we're already getting into that danger zone that if things don't start having the wheels turning probably in the next week to 10 days, we're definitely going to be in a crunch situation. But the idea is that people want to take advantage of this huge exemption that Carl mentioned of over $23 million for a married couple, and over $11 million for each individual. So the idea is that while we have this huge coupon, as I call it, to be able to gift away assets without paying a dime in gift taxes at the gift tax rate of 40%, so you're saving all that by gifting this year up to these huge amounts. But next year, that may not be an available opportunity anymore. And that sort of is the genesis of this entire program, is that this is the time to make the gifts or decide to live with whatever the rules are going to be next year. Now, we say the rules next year. Well, people are saying, well, even January 5th, if the Georgia runoff elections go on the Democratic side and the Democrats control both the House and the Senate, it's still going to take some time, right, for President Biden at that time to be able to implement tax law changes. But we have seen it before that the passage of tax laws, even if it happens in September or October of next year, it could be retroactive to January 1 of 2021. So that's just a few weeks away. And so that could happen. It's constitutional. This has been argued before because it's not a new tax. It's just lessening your exemptions from an existing tax. So it will make a lot more things taxable that weren't taxable before, and the rates can go up. Right now, there's a 40% gift tax if you gift over these huge exemption amounts. Next year, if the exemption amounts drop to, I guess the numbers we're hearing is $3.5 million for estate tax exemption, possibly indexed for inflation, so it could be a higher number, but also a $1 million cap on making lifetime gifts. Maybe all you get is a free ticket on gifting. And if you go $1 over that, then every dollar above that will be taxed at maybe a 55% tax rate, because that's the rate that's being discussed as well under the new administration. So this is an opportunity in a number of ways.
So with that, we're going to move forward in our slides, and we're going to go to the next slide. And we're going to talk in general about estate planning goals and how to lock in the exemption now. Obviously, there is a considerable difference between a $23 million exemption and what could be as low as a $7 million marital exemption. This is the time to take advantage of that. It doesn't have to be the full $23 million. Obviously, it can be any incremental amount up to that makes sense for the client. Each individual family will have different goals and different requirements. And with that, there are ways to structure various recipient trusts and other entities that we can get that advantage of. Right now, when we talk about locking in the exemption, we talk about ending the future for any estate tax to be imposed on those assets in the future. So there are mechanisms to do that. We're going to get into that. Ed, do you want to talk about the split gift?
Sure. Yeah, the split gift that's mentioned there on the slide is saying that, you know, even if only one of two spouses really has the funds to make huge gifts right now, and so you're thinking, well, each individual only has this $11.58 million amount they can gift tax-free. Well, actually, that individual, as long as he or she is married, can use the full over $23 million exemption, because you can use this tax fiction that the spouse owned half the assets that are being gifted, and therefore you get two exemptions that can apply even though the gifts are really coming from just one of the spouses. And so this is a great way to, for any married person to move a huge amount of assets into a gifting mode and giving it to children, grandchildren. You can throw in cousins and siblings and anybody else you want, parents, if you feel like it, have them be donees of these gifts as well. And of course, the idea is that you don't want to just give these things outright to these folks, because who knows what could happen to the money at that point. They may spend it in ways that you wouldn't have imagined or preferred. Also, they could lose the money if they end up having a creditor problem someday. If you give it all to your children and then they end up in a terrible divorce or a bankruptcy or whatever, of course, you know, hard to file bankruptcy with those kind of assets, but they've squandered a lot of it, and then they lose the rest to a bankruptcy, there it goes. So the idea is that you would gift to a completed gift trust, as we call it, that would be for the benefit of all these family members that you want to benefit from these gifts. And that way you can now dictate the rules with regard to how those assets will be used. This will determine when the children, for example, will be able to use the money in the trust, and make sure it's not being used for purposes that you would have frowned upon. So the idea is to transfer the amounts of the gift tax free this year to a trust, and using the split gift method, you've got the full, you know, $23+ million exemption amount that you can play with, gift tax free. But if you use something called a discounting LLC, you can move even more than the 23+ million. You can move, you know, it could be, you know, closer to 35 million, for example, if you've got the right appraisals and the right mix of assets that are inside this LLC. You can drop those assets into an LLC first, and then usually there's a little bit of a seasoning period here that you don't want to immediately turn around and gift it right away to the trust, but you can ponder on the polls and all that, and who you think is going to win the elections in January, and it might change your mind at that point to think, you know, maybe I should go ahead and gift this LLC to a trust now, and then you can then go forward, move that LLC into the trust, and now that the fact that the trust doesn't own the assets directly, instead it owns an LLC wrapper that sort of limits what rights the trust has to these assets, because now the assets are being controlled by a manager of that LLC, who can control when distributions are made from the LLC to the trust, allowing the trust to then turn around and make distributions out to the kids or whoever. The fact that the trust is one step away from those assets is what allows for what the IRS calls discounting of the assets, and therefore you can gift larger amounts than the exemption amounts, because the IRS will treat it as if the value is lesser because of the fact it's inside an LLC.
There are two types of primary discounts that are levied in these circumstances. One is a lack of vote discount, what we call a minority discount, and the second is a lack of ability discount. If you are an entity and you own an interest in an entity that's a non-voting entity, a non-voting interest, and you go out to the market and you try to sell your interest to a third party, generally they're not going to pay you a dollar for dollar fair market value for an interest that is non-voting. So with that, you get these discounts, and that's very important. I lean more on the conservative side of discounts currently, just because of some of the tax court cases where the IRS has had some minor victories against discounts. It is a constant litigation area. That's another reason I like to be conservative. But the valuation companies that value these interests, they do it pursuant to certain models for estate planning and gift tax planning. You must have an appraisal. Anyone that does an estate tax or a gift tax transfer will need an appraisal, because if you go over, you still have to file a gift tax return. That's a minimum requirement. You put the IRS on notice that you're transferring this amount of assets. So when the audit comes, because there's a high likelihood of an audit, especially if you're maximizing the credit at $23 million, you need one of these appraisals to support the valuation based upon the discounting features. And all of the valuation companies use these models for that purpose. There is also a very big concern, which I'd like to have Ed discuss, which is the Powell powers, that the IRS has recently attacked several of these structures based on Powell. So Ed, please.
Sure. Right. Yeah, that's a very common desire that people have when they want to make gifts, is they want to continue to have control over the assets, continue to manage the assets, because that's how the assets got to be of such value where they are today, because the client had that savvy and knew how to parlay that into a more appreciated, valuable asset. And they want to continue to have that interplay and control and input on the management of the assets. So the Powell case that Carl mentioned was a fairly recent case, a few years ago already. It's hard to believe, but 2017, IRS and a tax court looked at a LLC that was gifted away, and the person who made the gift continued to own an interest in the LLC as well, because they didn't want to give it all up. And that was looked at, and it was decided that, well, then you have certain powers over these assets. You can participate in a vote, for example, as to when a distribution is going to be made by this LLC, and that is affecting other people's enjoyment of this asset. And those are the key words right there. If you can affect the beneficial enjoyment of the assets that you've gifted away, if you can continue to affect that beneficial enjoyment with respect to any of the beneficiaries who are receiving this as a gift, that will put all back into your taxable estate under this Powell analysis.
And just one comment, Ed, on that is that a lot of structures that were done prior to 2017, at least by you and I as practitioners, do not have Powell coverage in it. And you're going to address that now, but it's very important that certain powers are curtailed and limited. So, please address that issue as well.
Sure. Yes, those older LLCs do have that problem, and so I guess they are ripe for an audit someday. And so the idea is that you can take those older agreements and have them modified now in a way that cuts back your powers as a co-owner or a manager of these LLCs that either have already been gifted away or you're thinking of gifting away. And this way you now got it so it's Powell compliant, as I'll call it, where you still can have control over selection of investments by the LLC, collecting rents on commercial properties, knowing how to reinvest the proceeds if the property is sold. You can continue to have those type of management powers. But when it starts to transgress into you being able to decide who can get a distribution from the LLC, or even some things less obvious, like what if the recipients of this LLC that you've gifted to want to sell their interest to somebody else, like maybe their spouse, or maybe to one of their children, your grandchildren. You cannot retain the power to veto that. You can't say, no, you have to get my consent for you to sell your interest in this LLC. You're affecting their beneficial enjoyment of this property, that'll pull it back in your taxable estate.
And, I'm working on a case right now, which is interesting because we have a S corporation that has both Class A and Class B shares, and the Class A controls. And we did a transaction back in 2016 where we alienated away a certain amount of shares in a grantor trust type transaction, similar to what we're going to get into. And now we are with the higher exemption in 2020, we're transferring more stock. So the decision was made to divest the Class A voting. instead of the Class B remaining shares, so that the acquisition trust now will actually have control, complete control over the S corporation versus the client maintaining the sole voting Class A shares. So, you have to look at each entity separately. There are limited partnerships. Those limited partnerships have general partners. Those general partners have those control elements. You have LLCs that have both non-voting and management voting interests. Those have to be looked at. Or in my case now, we have Class A, B, and an S corporation. So there are many fact patterns to look at. And if any of these have entered into these type of family transfers in the past through any of these entities, the internal operating documents for that entity should be reviewed by Ed or I to confirm whether or not there is an existing problem. And if there is, we can recommend those changes for each of you to comply with the Powell rules. So on that, next slide. Ed, you want to take self-settled or not?
Sure, I'll jump in on there. Yes, the idea that we're talking about now is not gifting assets away directly to your family members who can do what they want with it. Instead, let's gift it to this completed gift trust for the benefit of these family members. And then going back to sort of the idea that we were talking about, how clients love to continue to have control over the assets. Well, they also like to have, clients definitely like to have some beneficial interest in these assets as well. They would like to be able to receive money from the profits of these assets to continue to live on. If they put a lot of assets into this trust, and now let's say the assets that you have kept out and not put into the trust somehow go belly up because it was a bad investment, and now all of a sudden your good investments are all inside this trust, but you don't have access to it because you've given it away. So the idea is, well, can't I continue to be a beneficiary of the trust, this completed gift trust, so that if financial situations do change someday, and family situations have changed, whatever that might affect you, you would be able to receive a distribution from the trust if you decide that you want to continue to be a beneficiary of the trust. And that's what they call the self-settled trust, which I know a lot of people viewing this right now are very familiar with self-settled trust, trusts that are set up where you are yourself a beneficiary. But now we're talking about a trust that removes assets from your taxable estate. A lot of your standard asset protection trusts that you see were not designed to remove it from your taxable estate. It was more for other estate planning goals, asset protection, probate avoidance, all that. But a completed gift trust that's getting it out of your taxable estate has a higher scrutiny level with the IRS. They want to make sure that you have not maintained or retained too many strings to this trust that you've gifted to. And if you're a beneficiary, that could raise some eyebrows. If there were an audit, they may ask additional questions about, well, exactly what rights do you have to these assets you've gifted away? So that's why it's very important to design these trusts with, for one, an independent trustee who is the one who has full discretion and authority to make distributions back to you as a beneficiary, but you certainly can't compel the trustee to do that. You can't direct the trustee to do anything. So that's the reason they call them trustees, I guess, is because you trust them to do the right thing at the right time, at the right moment, as long as it's their decision and they have their own reasons for doing it. The fact that you're a beneficiary, the good news is a trustee does have an obligation to act in your best interest along with the other beneficiaries. So trustee is duty bound to certainly try to do what's best for the family who are beneficiaries. But the reason we suggest, oh yeah.
Go ahead. No, we do also have much more flexibility in the drafting of these self-settled trusts, and we do have the ability to add fiduciaries in addition to the trustee that could be a family confidant, friend, relative, somebody that is close with the grantor settlor, for example, a trust protector, or someone that may have powers, for example, to amend a class of beneficiaries. My view with these self-settled trusts is that for the most part, the IRS will always argue that assets should be included in a decedent's estate as long as they maintain a beneficial interest. I personally don't want to give the IRS that power to audit the client And with the use of a protector or otherwise, we have the ability to create scenarios where we could change the beneficial class, possibly add the grantor settlor later, or also design the trust as a grantor trust where the trust can loan money back to the grantor settlor at rates that are extremely advantageous. So we do have a lot of flexibility. Obviously, there's 19 states that offer self-settled trusts. Each state has a few specific little quirks on what's allowed, what's not. They vary slightly, but most of the states allow dramatic drafting capability for planners. And we work with attorneys in all the states where we set up domestic self-settled trusts. And we also do a lot of offshore options, which Ed can address as well.
Sure. Yeah, the offshore option is a nice extra component that we like because it makes it even more certain that if you do decide to be a beneficiary, or if you are added on as a beneficiary later, by a protector who's been designated inside that trust instrument, at least you have the better argument that you are not in a situation where if you are sued, the creditors can't say, well, you're a beneficiary of this trust, so get those assets and pay your judgments that we now have against you in this lawsuit. You can say, I'm sorry, but I have no authority. I'm not the trustee. I don't own these assets. I'm purely a discretionary beneficiary if the trustee decides if and when to ever make a distribution to me. And the reason the offshore adds, I guess, some oomph to that, I guess some teeth to it, is that if you set it up in one of the 19 states that allow for these self-settled asset protection trust in the United States, there is more of an argument if you don't live in one of those 19 states. There's more of an argument that the court might decide to apply the laws of the state that doesn't have the asset protection trust law in place and treat the trust as if it's an alter ego or invalid from the get-go because you're a beneficiary of the trust. And then, for example, Colorado doesn't have asset protection trust law. Nevada does. So if you live in Colorado, you have a Nevada asset protection trust, but you get sued in Colorado, I guess it's possible a court could look at that in Colorado and say, well, we don't recognize the protections of self-settled trust here, so we are going to lien the assets in this trust. Then the plaintiff takes that judgment, takes it up to Nevada and says, okay, we're enforcing our judgment here. And the question comes up, does Nevada have to honor a Colorado judgment? The US Constitution has this full faith and credit clause saying that in certain situations, yes, one state may have to give credence and enforce a judgment from another state. If you go offshore, there's no such constitutional type of situation there. The Constitution does not reach any sort of jurisdiction over the offshore trustees to have to recognize a US state judgment.
I will say as well that if you do go offshore, you're increasing your tax compliance requirements greatly. In the United States, you have a self-settled trust, an irrevocable trust. It's a grantor trust generally. You'll file a 1041 tax return, and it'll kick the income out to the grantor settlor. The offshore options also are grantor trusts, but with that, you have to add around 5 or 6 tax returns to your filings. And the cost to manage offshore is a little more than the domestic option, depending on what state you're in. Nevada has always seemed to be the best price state for self-settled trusts. Delaware is quite a bit more, and other states, it's all over the map. But we do know that the offshore option will raise the fee character and also the compliance character. The offshore option involves, as I said, you have to file what's called a 3520A, a 3520, possibly a FinCEN 114, an 8858, an 8938, a 5471. There's several forms that get attached to each of these structures. So you have to expect that increase in cost, but the value is in the asset protection. The value is in diversity of opportunity. If you move assets into an offshore option, you're most likely dealing with an international bank, possibly in Switzerland. It's a perfect opportunity for planning in Switzerland. There's no restrictions on that. You just, as I said, have to be tax compliant. But the Swiss banks can offer additional investment opportunities in the Eurozone and globally that most US providers cannot offer. So there are reasons to go offshore. Obviously, if a family is looking at something like expatriation, there may be another valid reason to go offshore. When you talk about retention of management powers, Ed, what are you talking about in general?
Yes, this is the idea that if you do gift assets this year to take advantage of this exemption amount, the question that we do get quite a bit of is, well, can I also be a trustee of this trust? So not only would I like to be a beneficiary, but I'd also like to be a trustee so I can actually be involved in the management of the trust assets. So we're assuming that there's no LLC in this picture. We've already covered that. But the client sometimes will like to be a trustee. And that's where you're really starting to invite more and more scrutiny, especially if you're both a beneficiary and a trustee. I would never advise being both. So you might want to pick your poison there. But if we have seen some situations where a client was adamant about being a trustee, so we made them what we call an investment trustee, where they only had powers to manage the trust assets. Once again, they just have the ability to decide how assets should be invested, how they should be reinvested when they're sold. What's their balance of equities versus fixed income, alternative investments or whatever. They like to have that ability to call those shots and enter into those types of investment vehicles. And as long as we can cut the powers short to just those powers and not allowing you to also, as a trustee, to make distributions, you can't terminate the trust, you can't amend the trust, you can't choose to have one beneficiary receive more benefits from the trust than another, because all those, back to those magic words, all those affect the beneficial enjoyment of those trust assets. But the IRS does not treat you just having investment powers over how the assets are managed as a beneficial enjoyment of the assets, because bottom line, the assets are there, they'll either grow or they won't grow. But the ultimate beneficial enjoyment by the beneficiaries is when they get money from the trust by way of a distribution. So as long as you don't have those powers to affect those types of, interest with respect to the beneficiaries, allowing them to have distributions or whatnot, you could have these curtailed powers as an investment trustee. But again, tread with caution. We just need to make sure that we're drafting it just right and having it administered properly.
And, one of the things we do offer is a hybrid type trust, an integrated estate planning trust, which we are trying to leverage the foreign jurisdiction law in what is considered a U.S. trust. It's a trust that's drafted in a way that we continue to have a U.S. trustee in place, along with, say, a Cook Islands trustee at the same time. Because you have a U.S. trustee, it could be, like I said, a professional or a friend or a family member. That trust is not considered a foreign trust at that time. You kind of get the best of both worlds because you have an asset protected trust that is leveraged under Cook Islands law, but is still qualified as a U.S. trust. So you don't have to have the international tax compliance. There are some benefits to that, but in the event that a distress event occurs, then that trust could become a Cook Islands trust rapidly, and the Cook Islands trustee is already in place with that option. So there is that hybrid option as well. So we're going on to exit strategies. Before we get to that, we're going to talk about a few other topics, but I just want to briefly address kind of the overall basic structure of what we're looking at here. We've been talking about entities and discounting and different types of trusts. The reality is the trust is irrevocable. The trust has family members, friends, charities. It depends who you want to layer in the trust. And there's a transaction that occurs. Ed will talk about step up in basis because that's incredibly important. The way basis becomes a part of this discussion is based upon whether or not there's a gift or a sale of assets. And both of those structures have value and both of those structures have benefits. And what is right for the client has to be analyzed based upon the numbers and based upon actual analysis of dollar amounts in that context. My advice to most clients is look to transfer assets that have the most future appreciation built up in them. As we spoke about earlier, we want to remove as much as possible from a decedent's estate. And the way to do that is to transfer assets that you believe are going to appreciate the most out of all your asset holdings. So we'll get back into that. I just, when you think about making these transfers, you just have to analyze which assets are going to be appropriate for the strategy. But we're going to get into exit strategy. So Ed, you want to just talk about disclaimer period?
Sure. The other common question that we are getting is that, well, let's say that I transfer these assets, huge amount of assets into this trust, and then next January 5th, the Republicans maintain control of the Senate. So now we feel like we have this reprieve now. There's not going to be any sweeping tax law changes to the state taxes, at least for the next couple of years, when midterm elections or whatever come up, or if there's some sort of change in who's serving in the Senate. But the idea is that after January 5th, if I feel comfortable and I think that maybe I shouldn't have done this and I want the money back, is it too late? Have I already used up my exemption and now I'll never get it back again? Well, there's interesting discussions that are going on about most states, well, all states have a disclaimer statute that say that if you do give assets away and the recipient, so we're talking about a trust here, completed gift trust, if the trustee of the trust says within 9 months, and I think some states it may be 6 months, but under the IRS code, it's a 9-month period that the recipient can say, I don't want these assets. It was very nice of you, but take them back. I know you were probably doing this for tax reasons, and that's not really a concern now. So we're rejecting the assets in essence. And that means that again, you got to look at state by state statute, but a lot of the statutes say that if that happens, then it relates back to the date that the gift was made. So if the gift was made in 2020 and the disclaimer by the trustee happens in July of next year, it's as if the gift never occurred in December of 2020. And it totally negates the whole transaction and you're back to where you started. I guess you're out the cost of creating a trust and the legal fees of setting it up and opening up an account for the trust and all that, I guess, brain damage that you went through to do this, but at least you get the assets back. But it's not quite that simple. That's the gist you get when you do a preliminary search in the law as to whether or not this can be unwound that way. But it gets very dicey. It's much cleaner if it was just a gift to your children and they disclaimed it within 9 months. And if the state law says it would revert back to you as the donor, then that's pretty clean. But when it's a trust that you've gifted to, it's not as clear whether the trustee disclaiming that asset is a full disclaimer, because a trustee only has legal title to the assets in the trust, but the beneficiaries have what they call equitable title or beneficial title. So do they also have to disclaim? And this is sort of the areas that would take more exploring case by case for any particular client to see if that's something that needs to be looked at further. Or you might even say, hey, I'll chance it. I want to use the exemption regardless, because even if it doesn't change back to a lower number January 1 of next year, many people have told me they think it's going to happen eventually. I mean, the country needs the money. These huge exemptions are probably going to go away. And I can kind of see where they're coming from, because in 2025, on December 31, the next day, the exemptions automatically drop back down to the old lower numbers again, if Congress doesn't re-extend it in the meantime. And a lot of people think Congress is definitely not going to re-extend the high exemptions after 2025. So I don't think the disclaimer period is such a big deal. I think I would go ahead and not even depend on that. I would go ahead and make the completed gift if it were me. If I had over 23 million to put in the trust, and figure that it's probably a good thing, because someday if the exemptions do go away, I'm already in, I'm already exempt. And as Carl mentioned, if there's a protector in place that might someday see it my way to add me on as a beneficiary later, allowing me to receive distributions from this if I ever were to need assets again, because I've somehow lost my own assets that I didn't put in, at least I have that comfort zone to think about.
And additionally, exit strategies, we talk about powers of appointment because that's a very flexible mode of allowing assets to be distributed from a trust structure where you're actually giving that power to an individual to appoint assets to a third party. And there are various types of powers of appointment, whether it's a special power of appointment, a limited power of appointment, a general power of appointment. There are ways that we can design those powers to allow distributions of assets outside of the trust structure where that individual has the power to transfer those assets upon request of the trustee to a third party. That could even involve transferring assets back to the grantor settlor in certain circumstances. We spoke about amendments earlier, and Ed just mentioned it again, is that in the event that you, as the grantor settlor, appoint a confidant or a third party as the protector, it cannot be someone that is subservient to you under Tax Code Section 672C. It has to be an independent third party that you do not control. But a relationship matters. And if you have a relationship with a third party protector and they have the power to amend, that could be a great exit strategy because they would amend the document, add the grantor settlor as a beneficiary, and then, as Ed said, you become an eligible donee for purposes of distributions from that trust. So we do like that flexibility. Ed, you want to talk a little bit more about these powers of appointment and amendment?
Sure. Well, one, the protector power, that's a one that's definitely in the running for the three choices: the trustee having certain powers, the protector having certain powers, or the beneficiaries having certain powers. But to focus on the protector is a good choice for a number of reasons. One is that most states, and definitely offshore, again, this is why I like the offshore, but a protector can be a non-fiduciary. So they don't have to worry so much about, well, gosh, if I do add you back on as a beneficiary of this trust, am I going to get sued by all the kids because now I've diluted the pot? I've added another beneficiary. And that might be a concern to the protector who may be hesitant to add you back on as a beneficiary if he's worried about being sued. So a protector, a non-fiduciary protector, would not have those concerns. Now, I know some states will treat a protector as having fiduciary obligations. So again, we would look at this state by state if you're going to not use offshore. But that's one reason the protector is a more flexible person to have these powers. Even that being said, I still like the idea of putting guidelines in the trust agreement that sort of guides the protector as to what should he take into consideration when he's going to be adding beneficiaries. Don't just leave it up to the protector on his whim to just say, oh, I just felt like it, because I could think the optics of that could look bad, that someone might think that you were whispering in the protector's ear and giving him ideas. I like the guidelines being right in the trust agreement that say, look at the family values. What was the original family values that the settlor had when he created this trust, when the client set up this trust? What was he looking for? Was he looking for this money to ever be used for, terrorism or drug use or alcoholism? No. And so if you feel like some of the beneficiaries, one's joined a cult and one is about to, married badly and has a spouse that's probably going to be divorcing the child in the foreseeable future, maybe they will be knocked off as beneficiaries by the protector. But you got to have some beneficiaries. So maybe the protector would have to add some people back on, and maybe you as the settlor could be in that running to be added back on. So those are the guidelines to make sure the family values are being followed and sort of what the goals of the trust originally were.
When you talk about need-based, I mean, there's all types of drafting opportunities for these trusts. And a lot of times, I think someone sent a question in it, which you can address, but, you're talking about assets that are set aside for future generations generally. And as we've been repeating this, these assets should not be subject to future estate tax in the irrevocable trust. They are subject to income tax, obviously, on income that's generated, And as long as the settlor or grantor is living, all of those tax attributes will pass through to that grantor settlor's tax return. And the benefit of that is the grantor is able to reduce their estate even further on a tax-free basis. There's no gift taxes applied to the income taxes being paid by the grantor that are being generated through the trust. So they can further reduce their estate by dipping into their other assets to pay these taxes. Now, when you talk about needs-based, you talk about analyzing what is happening in an individual beneficiary's life. Are they a surgeon making $1 million a year? Do they need a distribution from this irrevocable trust, this dynasty trust, this legacy trust? Or can the assets grow inside the trust and be accumulated and continue to grow for future generations? Those are decisions that would be made by the trustee, potentially with veto power by the protector or not. There could be a distribution advisor added, or what I like to do, and Ed does a lot, is put a co-benefits trustee with a Nevada trust company so that you have an individual that can make those decisions while analyzing on a need-based analysis as to what each beneficiary needs. And these trusts can be designed to provide for either equal or unequal distributions. We really have a lot of flexibility. And the key really is that it's discretionary. They have to be discretionary. The trustees or the other fiduciaries in the structure, they have to make the decisions based upon analysis and no outside interference from a beneficiary. And that is important because that's what keeps these assets not subject to future estate taxes. When you look at those need-based analysis, again, you're going to look at all factors. And you can design those factors in advance, and you can put caveats in the document. For example, if you require a child to get a master's degree, for example, to be eligible, or you require, I see sometimes religious elements put in these trusts. So there's all kinds of flexibility. And now let's talk limited powers of appointment, Ed, because that's one of your favorite things to work on.
All right. And I will go ahead and read the question that popped in here. A question has just come in a few minutes ago asking what advice can we give on the next generation who will be inheriting these high net worth assets? And I think it's a good question because that goes right to, this is why you don't want to give these assets outright to family members, because they may not know how to handle this sudden inherited wealth. So the trust is again ideal because you can put it into the assets into the trust for the benefit of the next generation, but with that spigot being turned on and off just as needed to allow those family members to maintain their lifestyles. Even if they have a very nice lifestyle at your death, you can write into the trust that whatever their lifestyle was at the date of your death, for example, you want them to be able to maintain that lifestyle. So if they do lose their jobs or whatever, and they were used to driving 2 cars and living in a 3-bedroom house, at least this would allow the trustee to continue to give them enough money if they lose their house to buy them another 3-bedroom house and not force them to buy, an efficiency apartment or something. So, so this is a great way to handle the next generation inheriting this, is because it's only doled out to them on an as needed basis or as prudent basis as the trustee determines. And that way it allows the assets to be carefully managed in the meantime inside the protective trust. And also I've seen it where the trustee will sort of test the waters and maybe make a nice significant distribution, maybe $1 million, just to see how the beneficiaries do handle it. And maybe check back with them in a month to see if any of it's left. And if it's all gone, the trustee probably knows not to do that again. So it's a great way to kind of monitor the next generation so that they don't all of a sudden become the idle rich, as we call it, where they just sit back and decide not to even be a productive member in society and just wait for handouts from their trustee.
And there is an additional opportunity in what we call private trust companies for families. You can use an entity in certain states. Of the 19, there's several that offer these private trust companies where actual beneficiaries could be board members of those companies. Obviously, they can't make decisions as it relates to their distributions, but as long as they're in a minority position, and we generally like independent individuals to be on the board as well, there is a mechanism for a family private trust company scenario that may be interesting to certain clients as well. Moving forward, we're getting into step up in basis. This is a very interesting issue because the question of whether or not you gift an asset to a legacy or dynasty trust, which takes what we call a carryover basis. How much basis does the individual grantor, what did they pay for this asset? If it's $1 million asset that they invested in, but now that asset's worth $5 million, you have $4 million of built up gain in that asset during capital gain income, which right now we have preferential rates up to 23.8%, but under a Biden administration that may be repealed and it may be 39.6% on capital gain sales. So that's something we're monitoring. But in the step up context, if you gift, you get the carryover basis. When that asset sells in the future, they get that $1 million basis. If the asset sells for $5 million, the trust will pay tax on $4 million of gain. Or if it sells during the grantor's life, that may be a advantageous scenario, but there'd still be capital gain on that. The other side is if you sell the asset to the trust. Ed, if you sell the asset to the trust, what is the impact of that?
Yeah, completely tax-free, because the fact that these trusts are grantor trust, that means that the IRS will treat you and the trust as the same individual for IRS income tax purposes. So it's a sale to yourself. So no gain is triggered on the tax. Even if you take back an installment note with interest, you're not even taxed on the interest that's paid back to you for the sale. So it's all totally income tax free.
The note is taxable to your estate, correct?
Yes, since you're selling the asset to the trust, you do get back a note that has the value of whatever you sold to the trust. So that is a taxable asset in your estate. But the good news is the note won't appreciate in value. Hopefully the assets you sold to the trust will appreciate in value. So if they continue to double, triple in value over the next 10, 20 years, the note's going to be doing nothing but being whittled down, because if some interest and maybe some principal payments are being made back to you, the face amount of that note is decreasing all the time. And with today's very low interest rates, it's under 1%. I think the applicable federal rate is hardly anything. You would hope that the assets that you sold for this note that's earning very little interest, you would hope that the income being generated by the assets that you've sold to the trust are going to be producing a lot more income than that. So again, you're capturing all that additional income and appreciation on what you sold that grows out of your taxable estate, and all you have back is this note that's going to be dwindling in value. So your estate will continue to drop in value. And as Carl mentioned, you're continuing to pay the income taxes on all the earnings that the trust makes. So that's dwindling your estate even more.
And most importantly, the trust gets a step up in basis for the purchase price of that installment note. So if you're buying it at fair market value and that $1 million basis asset, the trust buys it for $5 million, they now reset the basis at $5 million, even though there's no recognition on the grantor side of the transaction on the sale. So you get that kind of arbitrage, and then the future sale, you're coming in with a $5 million value already. So how about swapping assets? How about exchanging? We talked a little bit about installment notes. I know we're going to close it up and open up to questions, but you want to close it out with some of your thoughts on those issues, Ed?
Sure. And we have some more questions coming in, so I'll jump to those in a minute too. But yeah, let me just maybe hit these final points quickly first. I know that I didn't quite address the limited powers of appointment on this PowerPoint slide. Just quickly, that was just the idea that if you really don't want to leave it to the trustees and the protectors to be able to find a way for assets to be used in a way that could benefit you, you can give the beneficiaries a power to appoint assets to anyone other than themselves, of course, because that would cause them to have a taxable estate. And so this comes in handy if, for example, one of your children is super successful and really has no need for the inheritance, doesn't even want it, but he can kind of look over the other three siblings. You know, one's a starving artist, one is a starving actor, and the other one's a starving, well, I probably should quit, I'm probably offending people, but whatever it is, the one successful child can be in control of being able to point the trust assets to anyone other than himself. So he could help out his siblings who might need money as they go along. And that's a great power to give the successful child, because he can then gift these assets to the other siblings without any gift taxes, because the money's really from you, not the sibling. And the fact that that limited power to appoint is so broad, that child could even appoint assets back to mom or dad if the child felt like, well, gosh, I know mom and dad never meant to have to sell their own home because now they have no money left and they've been paying all these taxes on this trust income, and it's become such a heavy burden. They need some money to at least maybe pay the taxes. So the sibling, the child of the client, can appoint assets back to the parents who created the trust. So that's a good thing for the power of appointment. The step up in basis quickly, and then I'll get to these questions because I know we're running out of time, is that if you do put assets into this trust and then years later you realize that those assets have appreciated quite a bit, and when you die, there will be no further step up in basis to those trust assets because they're not in your estate. Those assets are still going to have that inherent appreciation all built inside those assets. So what do? Well, maybe if you have some high basis assets like cash that's not in the trust, you can swap that cash for those lower basis assets in the trust. So now you've done an equal trade with the trust. Doesn't affect your taxable estate whatsoever because you gave quid pro quo, equal exchange. But now the assets with the lower basis are back in your estate. The taxable estate would have been the same, but at least now you get a step up in basis at your death. So that's a great way to wipe out the capital gains that were inherent in those assets. And then the other idea is if you don't have a bunch of high basis assets to swap with your trust, well, maybe you can buy the assets back from the trust for a note. And that way you've got the assets back in your estate, so they get the step up, and the trust has this, big note that will not be in your taxable estate. And I know there's been some split authority on whether or not when you die and your estate has to repay that note, is that taxable income to the trust? And I know it's gone both ways. I think the better argument is it's not, because it's really more in the nature of a gift. It's really not income that's being earned by, some sort of use of an asset or rents or royalties or interest or dividends in that sense of a third-party investment. But if you're worried about that, there's actually a strategy to even avoid the chance that could be taxable to the trust when the note's paid off, but we obviously don't have time to get into those types of details.
One of the things that is important is the last bullet point, which is asset protection and tax motive. Obviously, the IRS takes exception to transactions that are completely tax motivated, although a lot of the gifting transactions seem to be. Nevertheless, by the use of these structures, we're also getting the advantage of having asset protection as a primary concern and primary goal. And that diffuses some of the issues related to tax motivation and will give you a stronger argument on audit in the case that you are audited. With that, let's answer these two questions, Ed.
Okay. Yeah, it's interesting. You're right. It's a great defense on the IRS thinking you were doing this just for tax avoidance. No, you were doing it for asset protection. But then when the creditor comes in and says, well, you just set up this trust for asset protection, you were just trying to hinder a creditor, you obviously say, no, there was definitely a tax reason for doing this. So you kind of win either way. Okay, a couple of questions here. I'll just read it directly as it reads. It says, with the new administration, is there a possibility that charitable contributions will be capped and amounts over the cap will not be tax deductible? Now that's getting into more of the income tax Biden proposals. I know that there is discussion about putting limits on the amount that you can deduct under charitable contributions. And so I know there is a push as well. to do some charitable planning this year. I don't know, Carl, if you know more details about what's in the proposals on that.
I expect every area of taxation to be on the table.
Yeah.
Biden has put out a very long proposed set of changes, and charitable is one of them.
Right.
They haven't specified, the deductibility or the AGI issue related to how much you're going to be permitted to deduct, but it's definitely going to be an issue on the table.
All right. That's why I'm seeing a lot of chatter out there about setting up charitable trusts now, and making your charitable donations now, even if it's a donor advised fund that you can, front end load with, massive amounts of money. You get the deduction all up front, and then you can have that donor advised fund take care of all your future lifetime donations to your church, synagogue, Red Cross, whoever, and you never have to cut another check from your own personal account for that again, because the donor advised fund under your donor advising would probably take care of all those. It's interesting, just real quickly, I know that there was about a couple of years ago now, donor advised funds can even pay a pledge that you had previously entered into with respect to a charitable pledge, as long as you aren't directing, well, as long as you don't have some arrangement with the donor advised fund to satisfy your pledges. The donor advised fund can in fact use funds toward that pledge, and that's actually been condoned by the IRS. The last question I have on the screen here is, if you already have an offshore trust, do you need to create a new one for the self-settled trust? That's a question I'm seeing come up a bit this month, is that some people were thinking that the offshore trust for asset protection already took care of all these things we're talking about. This already removed the assets from the taxable estate, so we don't have to worry about this. But no, the typical offshore trust that have been set up in the past, the very typical design was that it is more for the protection and the probate avoidance and the marital deduction, the regular generic domestic type of estate planning provisions, but not getting it out of your taxable estate for purposes of what we're talking about today, so that you can make use of this exemption. So you would actually need to set up a new self-settled trust to be in addition to the one you already have, or there are ways that you could amend your existing offshore trust that's a little more involved, because we have to kind of look at exactly how it reads now and what we need to do. So it's not quite as clean, but it can be done.
Yeah, we actually are doing that. I'm in the middle of doing that right now with a client who has multiple international trusts. So what we're doing is amending a trust right now that has limited assets. It actually owns a 1% interest in a family LLC. And so what we're doing is the protector is in the process of removing the grantor as a beneficiary. We're going to be amending the structure and removing them. So what we have is a gift of the 1% of the assets that's going to retain in the trust, and then we're transferring additional assets in there as a gifting trust. So in essence, the settlor grant will have no additional rights in the trust. It's only going to be his children remaining, and with that, he'll file a gift tax return and report the additional gift. And then the children now that are the beneficiaries of that trust have the obligation to start filing certain tax returns related to their interest in the offshore trust, usually just an 8938. In this case, if it does have a foreign account, there's two children, so each child will have a 50% interest. They would also be required to file an FBAR FinCEN 114. So on that, there is that capability to do that. And as Ed said, you got to look at the provisions of the trust very carefully and make sure there's no conflicting data or provisions in those trusts that would keep the settlor grantor as a beneficiary.
Right. And I had some questions emailed in advance. Maybe in our minute or so what we have left, I can pick the ones that were sort of the more repetitive ones. And then, of course, if any of you have specific questions that we weren't able to get to today, or if I didn't get to your advanced questions, please feel free to call me. I'd be glad to answer these questions. But the one that we are getting a couple questions on is there still time to do this? And I guess the answer is, well, yes, I guess that's one reason we're doing this today, is because there is still time to do it. But as Carl mentioned, appraisals will be involved. And so we are finding that some people are saying, well, forget all that. I don't want to have to go through getting an appraisal, appraising multiple entities that are in my trust or that I own. So what I want to do instead is I'm just going to gift cash, or maybe even go out and borrow the money and gift that to the trust. And then after the end of the year, then I can buy them back. As we said, it's income tax free. You can buy the assets back once you have more time to get those appraisals and all that. And then you can take care of that at that time. That way
you can even swap assets. You have the opportunity to put additional assets in and take the cash back. If there are any additional questions or anyone in the audience would like to address any of these planning opportunities with Ed and I, you have our contact information. We're happy to speak with you. Thank you very much. Thank you, Ed.
Yes, thanks, Carl. Thank you, everyone.
Take care. Thank you.